Supreme Court is open for business. I mean, they never really closed with the emergency docket all summer and the 24 emergency hearings that they held or emergency orders that they issued. But they're officially open for the 2025-2026 season. And we've already got 2 oral arguments under the belt. How did they go? Well, I got dressed up for it. I guess that's the best I can say. One had to do with conversion therapy bans, stopping people from trying to convert other people and pray their gay away or something like that. That went down a First Amendment rabbit hole that I think you're going to want to know about. And then there was a oral argument about who can attack Democratic policies in states about voting. In other words, who has standing to challenge mail-in ballot regulations states pass, usually blue, or absentee ballot, or how voting happens on election day. And the MAGA 6 was hard at work at the Supreme Court. You're going to want to know about it. And here's a clip from the Legal AF podcast. So the Supreme Court opened for business, and 2 oral arguments already in the books, one involving conversion therapy. Why is it always, it's always Christians that are trying to not bake a cake or not build a wedding website for gays or wanting to do therapy that it's documented by the medical and psychological professions as harmful to people, to try to change them back, have them stop being gay or whatever it is, or transgender. And the fight was over as First Amendment speech, that the patient has the right to hear the conversion therapy and the Christian therapist has the right to offer their opinions and open up the hood of the person's mind and monkey around in there and make it worse. And the question is that true or not? Is that right or not? What was your takeaway from the majority MAGA 6 and how they handled that oral argument?
Yeah. So look, this came about as a therapist in Colorado who, this hadn't happened to her yet, but theoretically, if she wanted to do this conversion therapy or this pray away the gay therapy, as I like to call it, that there's a law in Colorado, like in 20 other states, that says you're not allowed to do this conversion therapy, that it's actually harmful. And the MAGA majority justices basically are reviewing this from a First Amendment standpoint. They're saying, no, that law banning this conversion therapy is infringing on the First Amendment freedom of religion rights and speech rights of this therapist and the patients who she claims. And by the way, this law only applies to minors. So it's really the parents who would have to consent to this on behalf of their kids. And, so if it's a First Amendment, if this is a First Amendment right, and that's the analysis they were trying to adopt here, then then any law that infringes upon a First Amendment right has to go through the highest level of strict scrutiny. Strict scrutiny. It's a very high standard, and that's where I think if they adopt that standard, they're going to say, potentially, I think they're going to rule that the law is unconstitutional. But what really bothered me about this is how is this First Amendment, right? This isn't, I just don't see this as a First Amendment issue. This is medical treatment, right? This is not speech. No one's saying she can't go out and speak openly about her religion and her beliefs and that she's anti-gay. It's a matter of her administering a medical procedure. And mental health therapy is medical. It is a medical procedure that you are giving to somebody. And it made me think to myself, it's interesting how they want to give her a First Amendment right or therapists a First Amendment right to be able to try and do this, what has been proven to be a harmful medical procedure on somebody, but yet they won't then for transgender care, when a doctor and a patient make a decision that they want to take drugs or have surgery to change their body, right? Children who want to do that and who make that very difficult decision to undergo that, but it is a decision that is not protected, right? That, no, we're going to regulate that. That's a harmful medical procedure. To me, this is no different and should be treated the same. And the fact that they're going to say, oh, no, you can do this harmful thing. Like, you can't have it both ways. But so it's clear to me what's happening is, look, this is the separation of church and state no longer exists. And the Supreme Court, the MAGA right, is you bringing their religious views into, and their conservative MAGA religious views into the court, and they are going to make legal arguments to fit what their ideological viewpoint is, because it is inconsistent, in my view, to apply one standard for one and one for another. I mean, therapy isn't speech, it's treatment. It's a medical treatment. And so, but I think, I mean, I don't have a crystal ball, but I think that there's a chance that she wins, and that the rights of LGBTQ people are really, really put back. And it's really harmful. You know, there's been studies that talk about how this conversion therapy can be very harmful and create can actually be worse, right, for people who then could want to consider suicide or other really harmful acts, because you're being told that who you are, there's something wrong with you. And it's really sad. This case makes me sad.
Yeah. And there's a MAGA majority to find on First Amendment grounds that conversion therapy bans in 22 states, including Colorado, violate the First Amendment under strict scrutiny. And I think that's what the ruling's going to be, just managing expectations here. As we roll into the second case, which was a case on its face, the merits of the case is about whether states like Illinois and other places can extend the time for a postmarked ballot, postmarked on the day of the election, but received up to 12 or 14 days later, because the mail sucks, especially overseas mail, is unconstitutional or not. Does it fundamentally have a state through its rules change the essence of the election and the day of the election, which is set by Constitution? I mean, Donald Trump wants an election day. He doesn't want early voting. He doesn't want mail-in voting. He does, except when he was using it himself back in the day, absentee voting, all the things that he sees as an advantage to the Democrats. He wants good old-fashioned stand in line, like, back in the day. Because like when I first started voting, and you too, Karen, there wasn't early voting. There was mail-in, there was absentee, and there was mail-in. It was strict, but you had to go down to the firehouse and stand in line. You got to a giant, okay, kids, gather around. It's going to be a history lesson. You went to this giant gray metal cabinet from like the 1960s or 50s that it was mechanical, not electronic. You went in, they closed the curtain. You switched the switch, they closed the curtain, and you went down with levers on a paper ballot that was thread through the back of the machine, and you hit your switches. Then there was one big giant switch. You sure you're ready to vote? At the top, yes. And then that ballot got dumped into the bottom of this giant machine and locked away until they collected all the ballots. That was voting. And Donald Trump wants to go back to a version of that because Democrats always have an advantage of getting souls to the polls and getting ballots and all that. So that's the merits, but that's not what was on full display in the oral argument. Because this was a procedural question as to whether a candidate who didn't lose by a little but lost by a lot could still have standing, the legal right to challenge who has the right, I guess is the better way to put it, and who can bring a lawsuit to challenge things like a state's election laws, which they're allowed to do by federal constitution, about whether it conflicts with another aspect of the Constitution or not. Who is the injured party? And you had a couple of people who challenged, MAGA Trumpers, but they didn't suffer any harm on the mail-in ballot problem because they didn't lose by the difference of the mail-in ballots. And Paul Clement, who's kind of come out and helped a lot of targets of Donald Trump as a former Solicitor General for George Bush, he was on the side of these people. He tried to frame it as the campaign continuing for an additional 12 days. The postmark has to be the day of the election. It has to be in the bag. You're not campaigning to change the hearts and minds of people waiting for their votes to come in. They should have already voted. But what was your impression of how that's going to go down with the MAGA 6?
I mean, I think first of all, I think that's a weird argument, because as the circuit below said, look, that was your choice to keep campaigning 2 weeks afterward. No one said you had to do that. As you said, it had to be postmarked by the day. I mean, look, there's some interesting questions because on the one hand, you don't want to make the rules harder for bringing election law challenges. But on the other hand, if it make it too easy, you'll flood the courts with a gazillion lawsuits and you'll never have results of any election. So, it's a tricky case. The whole thing about mail-in ballots, I mean, that's just going to impact so many people who are in the military, who are overseas. It's going to impact so many people. But this is just the fight continues on, this is all about Donald Trump's crazy assertion that the election was stolen and he's so anti-mail-in ballots. So we'll see. We'll see whether whether MAGA is going to whether the MAGA right Supreme Court majority, which is really what they are at this point, what they're going to do and whether they're going to continue to do Trump's bidding or not. But I could see them here. I think the argument that having too many lawsuits and never having elections be finalized, I could see that carrying the day ultimately because,
maybe.
I don't know.
I'm not as trusting as you are. I think they're going to widen the net of who has standing to bring these types of lawsuits, and they're going to loosen up the reins of injury and not require that a person show that the election outcome for their election would have been different based on the mail-in ballot or whatever election rule that we're talking about. I think there's no doubt in my mind that they're going to instruct federal courts below them to loosen up the ropes about standing, even though standing is the most fundamental thing. You see, we've talked about this before, right, Karen, with our audience. When the administration, it's all reverse engineering. When they don't want to reach something that would be helpful to like the liberal side or the Democratic side, they say, well, we'd love to help you, but this case we have to dismiss because there's no standing for the people that have brought it. Sorry, it's a nice case. Probably would have helped a lot of people in America, but you don't have standing. And then you got to go scramble to go find somebody who does have standing. But here they're like, yeah, go ahead.
No, I was going to say that could be, that's what they should say to the therapist in Colorado.
Yes.
Right. There's no case in controversy there. It wasn't like she was disciplined for providing this therapy. I mean,
how about the website designer? She didn't even have a company.
Exactly.
It was a fictitious company that she didn't even have up and running. She never designed a website in her life.
Yeah. So they bend the rules when.
Yes, they make them up. And when they can't find one in the toolbox, like when you're in your garage or whatever, and you're looking for something, you're like, God damn it, I wish I had that. They just make it up. They're like, oh, I wish there was a rule that who could create that? Right, we can. That, right, when you're too close to an election, you can't. Okay, the Purcell Doctrine. People are like, that must have sprung from the head of our framers at the Constitutional Convention. Like, no. Originalism, textualism, right? Oh, we must divine the meaning of what our framers said. Oh, that must have been part of the Constitution, right? No, it's made up bullshit that didn't even take root until the 1980s with people like Robert Bork carried forward by Alito until they got enough MAGA 6 to get a majority. It's all made up shit. That's why people have no confidence in the United States Supreme Court. And then as we've talked about in the shadow docket, they don't even bother explaining themselves anymore. They've reached the point where they're just like, just take our word for it. This is the ruling. What is it based on? We're not going to tell you. Where's the logic? Well, that's for another day. Where's the analysis? Where's the precedent being used? Well, that's just getting in the way. As the Sam Alito once said during an oral argument, let's not get bogged down in the facts of this case. I was like, what are you just admitting out loud that you don't even care to be in appellate court anymore? You're just issuing advisory opinions that try to bind us. I mean, the legitimacy of the Supreme Court, all kidding aside, is a serious matter, which is why the next administration, hopefully with a big D next to its name, needs to address it. We need Supreme Court reform. There is no, and federal court reform. There is no doubt in my mind now that in order to avoid a future Trump or a series of Trumps, we have to, whenever we grab the reins of power, we're going to have to pack the court, to quote, Franklin Delano Roosevelt. We need 15 seats. We need to add 6 more to balance this out and get a 9-6 majority of free-thinking people. And then, you know what? Give me and you a shot. We've had generations, 3 generations of complete Republican control of the United States Supreme Court. The presidency, sometimes we get it, sometimes we don't. The full House, the Senate. We haven't had the Supreme Court led by Democrats in like 75 years. Give us a shot, folks. Let's pack the court. Let's get 15 or more on there, and let's return civility to American life. What do you say?
I mean, it would be nice to just have also judges who just actually interpret the law. Like, it's just
you cockeyed optimist, Karen. You're not happening in this world. We just got to play by the new rules and beat them at their own game. I mean, to use a sports metaphor, Florida teams are winning the Stanley Cup. Who would have thought ice hockey in Florida? All right, we've been given the rules. We got to beat them at their own game. Yes, keep our ethics, keep our morality, but stop with the niceties and stop with the. I'd like to even see sharper questioning in the Supreme Court. I'd like to see a better job being done by the legal counsel that supply a lot of the cross-examination questions to the senators and the Congress people. I mean, some of them are former prosecutors, so they know what they're doing. But I could have seen a stronger cross-examination. And the problem with even the senators, Karen, is that they're so sort of suffused in the traditions of the Senate and all that even when they get a lying sack of like Pam Bondi in front of them, they can't switch gears quick enough. Like you and I in court, you and I'll come in with our rough outline of how we'd like to do a witness or handle a certain legal issue. And then in the fog of war, it all gets lost, and you've got to quickly pivot. You got to throw away your outline, take your legal pad. I once had a case, Karen, where in the middle of my opening in front of a jury, the judge stopped me, called us all up to the podium, and said, "You can't make the defense that you're making." I said, "Excuse me?" They said, "No, I'm going to make a ruling now. I'm going to grant this other motion that have been floating around for years, and you now have to redo your entire opening statement. I'll give you 2 hours at a lunch break." So I'm there on a yellow pad in a diner in Fort Lauderdale, Florida, like pages were like flying in the air. It was like a Tasmanian devil, but I pulled it together and I gave an effing opening and we won the case. And I want to see a little bit more of that when the Senate and the House get their mitts and their grips into cabinet members like RFK Jr. and Pete Hegseth and Pam Bondi. We better be learning from what's going on in these rooms just as they are.
Yeah, I mean, I hope you're right. But what we've seen so far is all the administration, all they do is obstruct. They do not answer questions. So no matter how good the questions are, no matter how strong and sharp they are, the administration just refuses to comply and refuses to participate and just deflects. And I think we hold it against them, and if I was one of the senators, I would say, I would basically say, so if you had evidence that this did not happen, I assume you would bring it here, right? And, she'll have to answer that, right? I assume if there's no evidence of Donald Trump in the Epstein files, you would tell us, right? I mean, you have to bait her into answering some questions. And I agree with you. They have to get better at it, but they
Yeah.
have to figure out a way to get the questions answered. They just do.
And I think, a lot of them are fans of Legal AF. Sheldon Whitehouse is going to be on Legal AF tomorrow, being interviewed by Adam Klassfeld of All Rise News with us here on Legal AF. And, we've had a number of these people on, and Jamie Raskin's been on with us on Legal AF. And that is... I
hope Adam doesn't say, Popok thinks you should ask better questions.
No, but I did write a note to Adam that said that I was disappointed. I want him to tell Senator Whitehouse that I was disappointed when he asked the questions about the photographs that were in Epstein's house of Donald Trump with girls on his lap, that they didn't also use the Legal AF video that Jamie Raskin and Ted Lieu used 2 weeks earlier in the House. Like, oh, here's our moment. Legal AF's going to be back in the hearing room. No. So, no, that was, no, Adam will do a great job. And Sheldon's a friend of Legal AF. He's very close. People may not know this, but one of the great contributors on Legal AF is Court Accountability Action, led by Alex Aronson and Lisa Graves. Lisa Graves has a beautiful new book out. She's been sounding the alarm about John Roberts for like 30 years. And finally wrote a book called Without Precedent about John Roberts being a Trojan horse and what he's doing to destroy America. It's a beautiful book. It's required reading for legal AFers. That she's with Court Accountability Action. But Alex Aronson was Sheldon Whitehouse's chief legal counsel on Capitol Hill. And they have a very close relationship, and he's often with us over on Legal AF as well, as we're trying to bring newsmakers and the lawyers that are in the courtroom all together in one place, in one ecosystem. Kara, we're at the end. What do you got? What do you got for the audience?
Tonight's episode makes me want to go have a glass of Willamette Valley Pinot Noir, because I'm just thinking back to my times in Oregon, and there's just no better wine than from the Willamette Valley. So
I saw I was going to say earlier, I'm wearing blue, you're wearing red, but it's more like wine. So maybe it's more red where you are. But if you're around next a week from Saturday, I'm going to be in San Diego doing a live Legal AF hot take interview of Rob Bonta, the Attorney General, on the stage at a thing called Mardi Gras, which is a bunch of lawyers getting together, and he's one of the keynotes, and I'm going to be doing an interview of him. But the next day, there's a podcast called Bourbon of Proof. Do you drink bourbon?
I do not.
Okay. Bourbon of Proof. It's run by a lawyer named Robert Simon, and we're going to do a crossover episode. Bourbon of Proof meets Legal AF on a music stage where they're going to have DJs, house music DJs later in the day. I think it may end up being like Drunk Shakespeare. It could be like Drunk Legal AF.
I think it's really fun. I think it sounds fun.
Right. So look for that. Look for that starting next week. We're actually going to do the Rob Bonta interview, and we'll put it up soon as a live. I got all dressed up because you helped us get the podcast to number 25, our highest ranking on the YouTube weekly rankings. That's of all podcasts. We're number 1 in law and politics. That's because of you. Help continue to grow our audience. Slide over to the audio versions on Apple and Spotify. Leave a 5-star review and watch us and listen to us there. That all helps. Same thing on YouTube. And then come over to Legal AF Substack, become a paid member. That's the best way to support Legal AF and Legal AF YouTube. Hit the subscribe button there. It's all for free. No paywall, no outside investors. I appreciate everything about your participation in our audience. And I got dressed up, as I said. So until my next report, I'm Michael Popok. Can't get your fill of Legal AF? Me neither. That's why we formed the Legal AF Substack. Every time we mention something in a hot take, whether it's a court filing or a oral argument, come over to the Substack. You'll find the court filing and the oral argument there, including a daily roundup that I do called, wait for it, Morning AF. What else? All the other contributors from Legal AF are there as well. We got some new reporting. We got interviews. We got ad-free versions of the podcast and hot takes. Where? Legal AF on Substack. Come over now to free subscribe.